Good afternoon, and thank you for taking the time to join our webinar today regarding portability. A couple of housekeeping items before we get going, just so that all participants know that the recording as well as slides, any questions and answers obtained during the session will be provided and available to anybody who's interested on the HUD Exchange a few weeks after the completion of today's webinar. So also, if you have questions throughout the broadcast, please feel free to put your questions in the chat box and we'll respond to any specific questions that are asked during the webinar or at the conclusion of the webinar at the end of the presentation. So in advance of going through our presentation today, we want to acknowledge HUD's support for providing the funding to put on this webinar for all the participants. The materials based upon the work is being supported and funded under an award through the U.S. Department of Housing and Urban Development. The substance findings of the work are dedicated to the public. Neither the U.S. government nor any of its employees makes any warranties expressed or implied or assumes legal liability or responsibility for the accuracy, completeness, or usefulness of any information, apparatus, product, or process disclosed or represents that would not infringe privately owned rights. References herein to any specific commercial product, process, or service by trade name, trademark, manufacturer, or otherwise does not necessarily constitute or imply its endorsement, recommendation, or favoring of the U.S. government or any agency thereof. Opinions expressed in this document are those of the authors and do not necessarily reflect the official position of or a position that is endorsed by HUD or any HUD program. And so with that, we're here today to talk about portability within the HCV program. Today we'll be going over a portability overview, responsibilities of the PHAs, whether it's the receiving housing authority or the initial housing authority. You'll oftentimes throughout the presentation hear those referred to as an IHA or an RHA. So those are what those acronyms stand for. We'll also talk about the options of portability as it relates to absorbing versus administering ports, talk about the deadlines as it relates to what the IHA and RHA are responsible for providing to each other throughout the portability process. And then we'll talk about how portability interacts with the utilization of the voucher program and how that interacts with housing authorities' ability or inability to issue vouchers based off of what's going on the portability side, and followed up and finishing it off with special purpose vouchers and how they relate to portability. So today we have two presenters. That's me. I'm Mike Edens. I'm a VP with CVR Associates. I've been a former HCV housing director. I've been in the housing industry for over 17 years with extensive knowledge in pretty much every aspect of the voucher program, specializing specifically in CMAP, HCV program administration, PBVs, relocation, and HCV utilization. I'm joined today with my co-presenter, Tisa Tansey, who's a senior associate for CVR. Tisa is a former compliance and training manager. She has more than 15 years of experience in the housing industry specific to the Housing Choice Voucher program and specializes in HCV program administration, compliance, policy development, relocation, asset repositioning, and data management. And so with that, I will hand it over to Tisa to start talking about the awesome topic of portability. Go ahead, Tisa.
Thank you so much, Mike. Good afternoon and welcome, everyone. The Housing Choice Voucher program has many great advantages for families participating in the program, and one of them is their right to transfer their housing assistance anywhere in the United States if the area that they choose to live is administering an HCV program. This wonderful feature of the program is known as portability. And to get the process started, the family must contact their initial housing authority, which is the authority that either issued their voucher or the authority where they applied for assistance. The request should be made in writing, and the family has to meet different criteria. It's important for the family to know that there will be changes to either the payment standard, their voucher size, the screening process, etc., once they lease up in the jurisdiction of the RHA. So the family should be made aware of all of the changes, possible changes, and their rent portion so that they can make an informed decision on if they choose to continue to port. So, for instance, if the family is aware that their voucher size may be reduced when they move to the Receiving Housing Authority's jurisdiction, they may change their mind and decide not to port. Each housing agency has their own set of responsibilities and requirements so that the process for the family can be a smooth transition. So let's talk about the parties involved in the process. We have the family who will initiate the request to move to another PHA's jurisdiction. The request usually should be submitted in writing. We have the initial housing authority, which is the authority that first issues the voucher to the family. And we also have the receiving housing authority, which is the housing authority that the family wants to lease up at moving to another jurisdiction. Let's talk about some of the responsibilities of each of the parties involved. So, all parties have responsibilities. The family, again, will put the initial housing authority on notice that they wish to move. So, if they initially applied for or leased up in the area of or the state of Georgia, and now they want to relocate to the state of Tennessee, they will inform their initial housing authority. In accordance with the lease, the family must also provide sufficient notice to the landlord of their intent to move. So they can't just up and decide they want to move somewhere else. They have to still provide notice, proper notice to their landlord, and settle any debt, if any. Also, they must submit the request for tenancy approval to the receiving housing authority when they select the unit that they wish to lease. The initial housing authority responsibilities include sending a complete portability packet to the receiving housing authority. The housing authority must also determine if the family is in good standing and if they're eligible to port. They will issue a complete current signed voucher to the receiving housing authority, and several other forms must accompany the voucher. Part 1 of the Form HUD 52665, which is the Family Portability Information Form, the EIV report, current income verifications, and the current Form HUD 50058. If the family fails to submit their request for tenancy approval, the initial housing authority is responsible for terminating their assistance. Also, if the family holds a special purpose voucher, such as a VASH voucher or non-elderly disabled, which is also referred to as NED voucher, the initial housing authority must inform the receiving housing authority, and they must inform them by the code that's indicated on the 50058. The initial housing authority must also pay full HAP and administrative fees if the receiving housing authority is administering the voucher. So we talked about the initial housing authority determining if the family is eligible to port. Both applicants and participants must be eligible. So participants currently receiving assistance must not be in violation of the lease, and their move must comply with whatever the PHA policy is. Applicant families are eligible to port if the head of household or spouse had legal residence in the jurisdiction of the current housing authority at the time they applied for assistance. So the family was living in the state of Tennessee when they applied for assistance. They are on the waiting list. They decided to relocate somewhere else while they're waiting. As long as they were living in Tennessee when they applied, they are eligible to port. The initial housing authority is also responsible for restricting moves. There are some that must be restricted and some that are discretionary. So the initial housing authority may decide to restrict the move if the family is not income eligible in the jurisdiction, they must restrict the move. When they initially lease up in the receiving housing authority's jurisdiction, and if they're over income, if an applicant family decides to move to the receiving housing authority's jurisdiction and there are income eligible, of course, the housing authority cannot restrict that move. If the family is in violation of the lease, the move must be restricted. The PHA may have a policy of discretionary move restrictions, and some examples would be if the family breached an agreement with the PHA to pay any amounts owed, the PHA may decide to either forgive the debt, depending on what it was, or, of course, restrict that move. But again, PHA policy would determine. The PHA may have a policy to deny the family their move due to criminal background check or drug abuse. The family may not be in compliance with moving according to the PHA's move policy, so their move will be restricted. Or if there's insufficient funding, the move may be restricted. However, the local HUD field office must be notified within 10 days for any approvals for restricting moves due to insufficient funding. The receiving housing authority's responsibilities. Most housing agencies will brief the family as they're incoming to their housing authority. It's not mandatory, but it is common and it's best practice to do so. However, when briefing the family, it must not delay their search for housing. The receiving housing authority must also issue a voucher to the family and notify the initial housing authority of any extensions that have been given. The RHA must also notify the initial housing authority when a family has leased up in their jurisdiction or if they fail to submit a request for tenancy approval within the required time frame. The billing, which we're going to discuss, must be processed by the receiving housing authority if that authority decides to administer assistance for the initial housing authority. And also, any action such as a annual recertification, an interim, a move, and a participation, all of those must be updated on the 52665 by the receiving housing authority to inform the initial housing authority. So let's talk about voucher extensions. HUD expects that the family's paperwork is processed timely, and timely meaning within 2 weeks of receiving the completed portability packet. Per HUD regulations, the receiving housing authority's voucher must provide the family with a mandatory 30-day extension. The receiving housing authority's voucher must not expire before 30 calendar days from the expiration date of the initial housing authority's voucher. So for a better understanding, let's look at the example below. The initial housing authority issues a voucher and it expires on October 30th. The receiving housing authority's voucher may not expire before November 29th. The initial housing authority extends the family additional time, extends the voucher until November 30th. The receiving housing authority's voucher may not expire before December 30th. So we briefly talked about some of the forms that are required to send in the portability packet. So let's go a little bit in detail about the forms. The HUD 52665 is the billing document. Part 1 of this form is completed by the initial housing authority, and Part 2 is completed by the receiving housing authority. Please note that the initial billing submission must be received within 90 days of the initial housing authority's voucher expiration date. And in the initial housing authority is not required to honor any late billings. So it's important that billing deadlines are being tracked so that in the event, the initial housing authority won't deny the billing. The receiving housing authorities must submit the 52665 and the 50058 to the initial housing authority within 10 days of the effective date if there are any changes. The HUD 52665 form, part 2 of the form, is completed by the initial housing authority. And again, on part 2 is where the receiving housing authority will indicate any changes. The 50058 must be completed and correct. Line 2A should reflect the action type 4 for a port-in if it's a current program participant, or action type 1 for a new admission. So if the family has been selected and they're coming off of the waiting list, they will be reported as a new admission. The date of admission should be shown on line 2B, and this date can be found on the initial housing authority's 50058. If the portable family is a new admission, then the date of admission should be the date that the family leased up. So they ported in, they're an applicant, and they leased up on July 27th. That will be the date of admission. The voucher size of the family is shown on line 12A, and 12B is marked as yes, that the family is now moving into the unit. The cost billed per month is shown on line 12E, and this amount can be pulled from the 52665 that we looked at just a few minutes ago. And if the receiving housing authority is absorbing the voucher, then the cost billed per month should be 0, also shown on line 12E. And the initial housing authority's PHA code should be shown on line 12F. The Form HUD 52646 is the voucher issued to the family by the initial housing authority. Another voucher is issued by the receiving housing authority within 2 weeks of receiving the port packet. The subsidy standards in the receiving housing authority's jurisdiction will apply. So if the family ported in with a 2-bedroom voucher, it doesn't necessarily mean that they will continue to have a 2-bedroom voucher when they port to the receiving housing authority's jurisdiction. And also, reminder that the receiving housing authority's voucher should not expire prior to 30 days from the expiration date of the initial housing authority's voucher. The request for tenancy approval, otherwise known as the RFTA, is not a required form to send, but some PHAs will send it as a courtesy so that the receiving housing authority doesn't have to spend too much time either getting it online or pulling it out of the file. And some PHAs will request that the initial housing authority sends the request for tenancy approval as a part of the portability packet, but again, it's not required. So let's look at the flow chart and how the process flows for a smooth transition. So the initial housing authority will contact the receiving housing authority to inquire if they are billing or absorbing. The portability packet is submitted to the receiving housing authority, and if the income is outdated, the family will provide updated income verifications, and the family will submit the request for tenancy approval to the receiving housing authority. In some cases, if it is an applicant family and they applied in one jurisdiction, they ported to another, they leased up in the receiving housing authority's jurisdiction, they may choose to lease in place. So it's not uncommon to see where they're currently living on the request for tenancy approval. When an eligible family moves to another jurisdiction, the receiving housing authority can choose to bill, which we also refer to as administer, or they can absorb the family's voucher into their own program. Prior to the family porting to the receiving housing authority's jurisdiction, the initial housing authority, again, must inquire, and it should be in writing, about the receiving housing authority's intention to either administer or absorb the voucher. If the receiving housing authority says that they're going to initially absorb the family's voucher, this decision cannot be reversed later. If they inform the initial housing authority that they're going to administer the family's voucher, this decision can be reversed and the receiving housing authority may absorb the family into its own HCV program. So initial decisions that can be reversed are better than ones that can't. So it's important to determine and decide which one you'll do initially. And again, if you can reverse it later, those are the best decisions to make. Absorbing a family's voucher occurs when the receiving housing authority incorporates the family's voucher into its own program. The family's assistance is paid out of the receiving housing authority's consolidated annual contributions contract. We do refer to that as ACC. The family is no longer considered a ported family, and there is no ongoing communication between the PHAs and no billing arrangements. The initial housing authority may issue that voucher to another eligible family on the waiting list. If the receiving housing authority is administering the family's voucher for the initial housing authority, when the family ports and remains under the initial housing authority's voucher allocation, they will stay a part of their ACC contract. The receiving housing authority pays for the family's assistance and then bills the initial housing authority for the full housing assistance payment and a percentage of the ongoing administrative fee, or it's also referred to as the admin fee. There are billing deadlines that must be met, and HUD encourages PHAs to work together to resolve any billing disputes. It's important that billing issues are resolved to reduce administrative burdens and also to not place burdens on the family. If the initial billing is not received by the initial billing deadline, generally the receiving housing authority will have to absorb the voucher. The only exception to this rule is if the initial housing authority accepts the late billing. So they decide, hey, it's not a problem. We get it. It's a lot of work. We understand. We will accept the late billing. The receiving housing authority may absorb the family into its own program if there's available funding under its ACC and will not result in overleasing for the calendar year. Let's summarize some of the billing deadlines. So 30 days from receipt of the initial billing, the initial housing authority must make the initial payment. Any subsequent payments, so if there are any annual reexaminations, any interims, etc., those billings must be submitted and payments must be made no later than the 5th business day of the month. The initial billing submission must be received by the initial housing authority no later than 90 days following the expiration date of the initial housing authority's voucher. If the billing amount changes, the receiving housing authority must submit billing within 10 business days from the effective date of the change. If the billing arrangement is being terminated, the receiving housing authority must submit the billing within 10 business days from the effective date of the termination. We discussed making the initial decision to bill or absorb, and I gave a golden nugget that initial decisions that can be reversed are better than ones that can't. So I'm going to turn it back over to Mike to discuss portability's effect on utilization and knowing your data to help you make that initial decision.
All right. Thank you, Chiza.
You're welcome.
So thinking about portability, we work with a lot of PHAs across the country as it relates to utilizations of your program, and portability can play a big role in how it impacts your PHA as it relates to, how many vouchers you can issue from your waiting list, how many families you have that you're issuing vouchers to, who are unable to find housing because there's a lack of available housing within your community. So you might be having a lot of families poured out. And so portability plays a big role in the utilization of your program. And so what's important as it relates to portability and its effect on the utilization of your program is you've probably heard me say this before, you need to know your data, right? You have to know how many families you have that are taking their vouchers and porting them out. It's important to know where they're going. It's important to know how many vouchers you have coming in on a monthly basis. It's important to know how much port outs are costing you. And if you're administering ports, is how much you're earning from those port ins that you're administering in the form of new revenue fees or new revenues coming in through the admin fees by administering those ports. One of the things that I find myself talking to more PHAs about is letting them know that they need to start billing their ports instead of absorbing them. For a lot of PHAs, it's kind of commonplace for most housing authorities to just go ahead and absorb all ports that come in. But as PHAs tighten up on their utilization and start improving their utilization rates, a lot of PHAs are going to start finding that they're going to need to start administering ports. And this is something that I'm not just seeing kind of nationwide more and more. It's also administering ports depending on where you're actually located. So for housing authorities that are located in high market areas where families want to reside, or in areas where the PHA has a limited number of vouchers, I'm seeing more and more PHAs have to make the decision of administering ports, which I think is a good decision to make. To kind of summarize, the really most important thing as it relates to portability and utilization is you've got to know what's going on with your ports. That means having tracking systems set up to know where your families are going, know the PHAs that are administering and billing your ports, and just having accurate data available to you so you can make, as the PHA, good decisions on what you need to do with portability as it relates to the utilization of your program. And so when you're looking at the effect of portability on your utilization, I have an example up here, and every PHA is unique. So everyone's got their own 2-year tool that's got all of your unit months available, your unit months leased, how many vouchers you're projecting to issue, and all of that. And if you're not using the 2-year tool, you need to start using it ASAP. It is what now, July 27th, and we're 5 months from 2023 coming up. And so now is the time that you really need to be looking at your tool and preparing for 2023 and keeping in mind how you need to address your portability policies as it relates to the utilization of your program. So I will get off of my soapbox there for a second, but use your 2-year tool. When you're looking at portability's effect on utilization, you need to know how many ports you have coming into your program. If you are a PHA that has just been blindly absorbing any port in that comes in, you don't really have a good idea of how many are actually coming in and leasing up in your jurisdiction. And if you don't know that, what can happen is you can find yourself, as you improve your utilization over a period of time, is you can find yourself in a situation where you're overleased. And so it's important to have a good understanding of how many ports are coming in and how many are leasing up, because it's not necessarily tracked in the 2-year tool as it relates to utilization. When you're using your 2-year tool, you're really counting the number of vouchers that are issued or projected to be issued from your waiting list. And so you're not really putting your ports in there because those are kind of a wild card. You don't know how many you're going to get on a monthly basis a lot of times unless you know your data. And so if you know how many ports you have coming in, you know what you can and can't do with those ports and whether or not you should absorb or administer those ports. If you are just absorbing all of your ports, it can potentially augment and change the number of vouchers that you need to issue over time. As PHAs get closer and closer to maximizing out their HAP reserves and or voucher allocations, PHAs will need to start heavily considering administering ports so that you can continue to maximize the utilization of your program to the families that are currently on your waiting list within your jurisdiction. And so when you're thinking about what you need to start preparing for come 2023 as it relates to your utilization policies and specifically about portability, when you're using your 2-year tool and you're seeing that you're getting closer and closer to maximizing either your HAP reserves or your total number of vouchers, you need to really consider starting to administer ports so that you can continue to maximize the use of the vouchers that you currently have allocated for those families that are in your community. Additionally, getting to know the data as it relates to portability. If you have a lot of port outs that are being absorbed by another PHA, it's important to note that a lot of times these ports having 5058 transactions listed as type 5s and not necessarily as type 6s. And so how it relates to the utilization of your program in the 2-year tool is your 2-year tool is reflecting your EOP rates in PIC as opposed to type 5s, which might not actually be reflective of what your current turnover rate is. And so if you're in a tight market where you've got a lot of ports that are being absorbed by other PHAs, you're basically have the ability to lose track, or you're under tracking the number of vouchers that you're losing to your program in your turnover rate, because it's not tracked in PIC as an EOP, it's tracked as a type 5. Additionally, when it comes to port outs, one thing I hear a lot of PHAs talk about is they have very tight markets, right? PHAs are issuing 100 vouchers a month and they have a success rate of 38%. So 38 out of 100 families are actually leasing up. One of the things in very tight markets that it's important to inform your voucher holders of is their ability to port to other jurisdictions, which would therefore allow that family to obtain affordable housing that they may have been waiting years and years and years to get. There's nothing more disheartening than an applicant waiting on a waiting list for 3 years to get a voucher only to just never be able to use it. If you know that you have a very tight market with a very limited number of available units that families could potentially utilize, it's important to educate your voucher holders of their ability to port to neighboring communities or anywhere that has a voucher program, basically. But giving voucher holders that information is extremely important in allowing that family to utilize that affordable housing, because if your success rate's 38% and you issued 100 vouchers and 62 people aren't going to be housed now because you have such a tight market and you don't tell them that they can port it to somewhere else that they might successfully be able to utilize that voucher, then it's just going to be another cycle where you're having to bring another person up through the top of that waiting list, or that family who isn't able to utilize that voucher that they received would potentially need to reapply for a waiting list that might not be open again for an extended period of time. So when you're thinking about portability and you're thinking about utilization, if you know you've got low success rates because there's limitations within your jurisdiction, it's important to provide families who receive vouchers with information about portability. The other important factor as it relates to ports is understanding the cost of ports. Specific to port outs, right? So what you see on your screen is an example of a PHA. And looking at the VMS data for this specific PHA, they had 3 ports that they're being administered for, in which the per unit cost for those 3 ports is significantly higher than their per unit cost for their voucher program, meaning the families or the subsidy tied to a port is higher than the families that are currently residing within the jurisdiction. And this is something I see all the time where portability costs are significantly higher on the HAP side in comparison to a specific jurisdiction. This is another example of the situation where you've got a certain number of ports and a per unit cost that's significantly higher within a jurisdiction. And so you might be like, Mike, well, why are you saying to encourage people to port if you have a tight jurisdiction when it's going to cost us more to do it? I'm telling you that so that the families can receive housing, but also telling you that because there's availability to access additional HAP funds as it relates to ports. And so what you're seeing on the screen now is an excerpt from PIH Notice 2022-14, which talks about set-aside funding as it relates specific to portability. And I do want to put this out there that the opportunity to apply for this set-aside funding closed on June 15th. And so you can't apply for it now, at least as it relates to portability, but it's something that you need to be cognizant of in 2023 when set-aside funding becomes available, because if you have high portability costs, it will be important for you to understand that while it might cost more in HAP dollars for families to lease up outside of your current jurisdiction, there is a way to recoup some of that extra HAP funds that you're spending through the set-aside funding process. And so I would encourage everybody to take the time to review the set-aside funding notice, which again is PIH Notice 2022-14, as it relates to port outs where you have a per unit cost that exceeds your jurisdictional per unit costs, because oftentimes that additional cost can be augmented through the set-aside process. Additionally, if you are a PHA who's administering a large number of ports, through the set-aside funding notice, there's also applicability to special fees for portability. A lot of times, housing authorities are getting admin fees on port ins that they're administering that are lower than what their current administrative fee is. And so if you are a PHA who is administering a large portion of ports that is equal to 20% or more of your total vouchers, you can apply for set-aside funding in which you can receive additional special fees for any PHA that's administering a large portion of ports. In addition, understanding the cost, it's important to understand what the value of a port is. I was thinking about exactly what I was going to say earlier today, and I was for whatever reason it just came to me, and I was like, ports are kind of like a wild card, right? You can do different things with them, but in the long term, you need to make a decision on how you want to address those ports moving forward, whether you want to continue absorbing ports or if you want to administer ports. And really, the key to making good decisions is knowing what the value of that port is. If you're an administering PHA, where you're administering all of those ports, it's important to know what the administrative fee revenue you're generating from those ports are, and determining if those administrative fees are higher, equal to, or lower than what your current fee is, as well as in analyzing that data, understanding if it's actually bringing in additional revenue to your program that is beneficial to the continued growth of your program. So knowing what the value of the ports are and whether or not they're bringing in sufficient fee to cover your costs or if they're not. And that can help you make a good decision when it comes to deciding whether you should be administering a port or absorbing a port. So really kind of understanding the costs and kind of the bottom line as it relates to ports and utilization. It's important to know the data, right? Analyze the impact of the ports that you have on your program. If you're absorbing them, how many are you absorbing? If you have a lot of ports that are going out, understand how many you're losing on a monthly basis. if you're being billed for a large number of ports by one PHA, you do want to understand the risk that comes along with that. Oftentimes, PHAs will absorb, who have been administering, will absorb large chunks of ports at one specific date and time of the year. And when that happens, it can really throw off the utilization of your program. So a port that is being billed, that's being billed by a housing authority in Tennessee, that it's not, if it's being billed, it's not considered their port. So it doesn't count as a units month leased on the utilization side of the program. It's still counting as a unit month leased. If that port is being administered in Tennessee and it came from Georgia, it's still a Georgia port because it's being billed. However, if the Tennessee PHA decides to absorb a whole bunch of ports from one specific PHA, that PHA that was being billed and having those vouchers counted as a utilized voucher could potentially take a big hit in terms of now having a lot of unutilized vouchers quickly, which can really throw your utilization of your program into a bad place because you're not really expecting it. So one thing to realize when you're analyzing your program is to realize if any one specific housing authority is administering a large portion of ports, so that you can reach out to that housing authority and kind of get a heads up if they are considering to absorb them, because it's really going to have a negative impact on your utilization if you have a bunch of ports that are being billed be absorbed all at the same time. And so keep an eye on that. And kind of to that point, it's important for PHAs to communicate often with other PHAs, and regardless of if the other housing authority is administering your ports or you're administering theirs. Communication with other PHAs is extremely important to make portability work. And just from the utilization aspect, if you have a good relationship with a PHA and you talk to them frequently and you know what's going on with their ports, if you know what's going on with the utilization, it can minimize or prepare you for situations where a housing authority is looking to absorb a large portion of your vouchers that they're currently billing. Because if you don't know that it's coming, you can't do anything to prepare for, the loss of 30 vouchers in 1 month with a 30 days notice, because you can't replace those vouchers quickly. You'll need to pull names from your waiting list, go through eligibility, issue the vouchers, have the families find the units. If you have a lot of vouchers that are being administered, it's important that you talk to that other PHA and try and get as much advance notice if they're going to be absorbing your ports anytime soon as possible, so you can prepare for it. Because we all know the market we're in right now, and trying to utilize available vouchers is not something that's easy. So analyze your data, know where your ports are at, and build that communication with that PHA so you know what to do or you can prepare what to do if that PHA is looking to absorb a large portion of your ports. Additionally, if you are new to administering or you're considering administering ports moving forward, meaning the utilization of your program is up, you can just issue vouchers to maintain the ongoing attrition of your program. You might need to start making sure you can align the capacity needed to administer the vouchers. And generally, what I mean by that is if you're anticipating starting to take on 10 new ports a month because you're in a hot market where everybody wants to port to, you need to make sure you have staffing capacity as well as expertise to be able to bill those ports and receive payment from the other PHA to administer that ongoing and into the future. So know what your capacity needs are going to be as it relates to administering ports. Knowing the costs and or revenues related to ports, knowing that a lot of times Your port outs that are being administered and billed by another PHA are going to be higher than what your current per unit costs are, and that can be augmented through the set-aside funding often. So sometime in probably April or May of 2023, you're going to want to pay attention to that set-aside funding notice, as well as knowing the revenues as related to the port. So if you're new to administering a port or billing ports, know how much revenue you can anticipate to bring in through administrative fees to your program, so that you can align your capacity and potentially bring in sufficient staffing to handle the decision of now administering ports. And then kind of finally, looking at ports as a business decision. Is it important to the PHA to house families in your jurisdiction by utilizing available vouchers through your waiting list? Or are you just trying to maximize utilization any way you can, whether that's through the absorption of ports, or should you be looking at port ins as a business decision, meaning are you going to be bringing in additional revenues on a monthly basis for a new portfolio and revenue style that's going to help you better utilize the available funding that you receive? Looking at ports as a business decision that all PHAs should be taking a closer look at as you start preparing for how you want to handle the utilization of your program moving into 2023. And then finally, it's not something I put on here as a slide, but it's something I did want to mention because I've seen PHAs doing this, and I think it is a great idea. Specifically, PHAs where you have multiple housing authorities located in the same jurisdiction, right, or in the same county. If you're a PHA and you've got a county housing authority and a city housing authority or multiple city housing authorities, one way you can reduce the need to port families back and forth from a city PHA to a county PHA or likewise is by setting up jurisdictional agreements in which vouchers can be utilized from either program without having to go through the portability process. And I just wanted to touch on that to put it out there as a way to minimize the need to port people back and forth. If you find that you have a lot of ports that are being, moved 6 miles down the road to another PHA that has a more expansive jurisdiction, using jurisdictional agreements between PHAs can allow you to minimize the need to port families back and forth to each other, as well as provides opportunities for families to be more successful in locating units if they're able to utilize their voucher outside of the current jurisdiction of the PHA by having these agreements in place. And we have another training coming up on August 10th where we'll talk a little bit more about that, but I did want to kind of put it out there to all of the participants so you had an idea of ways you could minimize the need to port families back and forth, within a 6 mile radius if PHAs are in the same county and you've got a couple different housing authorities within that jurisdiction. It's an opportunity for PHAs to work together to improve the amount of affordable housing within the jurisdiction, as well as minimize the need to port families back and forth. And then kind of last thought is, as it relates to portability, if you're a PHA that's billing ports already and you have ports that are being billed by another PHA, if you're billing their ports and they're billing your ports, knowing your data could be an opportunity to know that maybe it's time you both absorb each other's ports, so you're not doing all of this billing stuff to try and minimize kind of that administrative impact that billing will have on your program. So knowing where your ports are and whose ports you're billing, if you can put those two together to reduce the amount of back and forth that you'll have to deal with as it relates to billing of ports, that's something that you should certainly consider doing, specifically if you know that Tennessee Housing Authority is billing Georgia's Housing Authority's ports and vice versa. You can absorb each other's ports and it's a wash as it relates to utilization. So know your data and make good decisions on the long-term utilization of your program based off of the information that's available to you. And with that, I'm going to pass it back over to Tisa to talk about special purpose vouchers.
HUD has allocated housing vouchers known as special purpose vouchers or SPVs, and these vouchers are issued to target a specific population. So PHAs must consider portability requirements unless HUD regulations specifically state or give special authority on handling portability for that program. Some SPVs include the HUD VASH vouchers, the Family Unification Program or FUP vouchers, the non-elderly disabled or NED vouchers. Currently, the HUD VASH voucher is the only program that has alternative portability requirements. An eligible family that holds a HUD VASH voucher must receive case management services provided by the Partnering Veterans Affairs Medical Center, also referred to as VAMC, or Community-Based Outpatient Clinic, also referred to as CBOC. So, VASH participant families may only reside in the jurisdictional areas where they have access to case management services, and this will be determined by the VA HUD VASH case managers. So, the housing authorities would have to be in contact with the VA case managers so they can get that information. If the receiving housing authority does not have a HUD VASH program, then the initial housing authority must be billed. The receiving housing authority does not have the option to absorb the family into its own HCV program if they do not have a HUD VASH program. For FUP and NED vouchers, there are specific portability provisions to account for the distinctions specific to those programs, but general portability rules do apply. The initial housing authority must submit the code for SPVs on the Form HUD 50058, and the receiving housing authority must always maintain those codes on that form. PHAs must set a policy to establish special mobility and portability procedures. Communication is key to successful portability transfers. Some best practices to incorporate when deciding to port a family out, when deciding to bill or administer the program, include the receiving housing authority confirming with the initial housing authority that the portability packet was received. It's good practice for the initial housing authority to provide the RHA with copies of photo IDs if the family is participating in the FSS program or the Family Self-Sufficiency program or not, providing citizenship status of the family, any reasonable accommodation information, or the family's EID status. Although those documents are not required, it will potentially help the transfer of the family run smoothly and not delay any processes so that there aren't a lot of vouchers that you have to expire if you're waiting for the family to submit information, etc. The initial housing authority should monitor if the family is going to remain under their voucher allocation, monitor and track any billing deadlines, and reissue vouchers timely. Also, as Mike mentioned, it's a good practice to analyze any impact that ports have on your program, considering any admin fees, and also making sure that the family is notified of possible challenges that they may encounter when leasing up in the receiving housing authority's jurisdiction, such as it may be difficult for them to secure employment, things relating to education for themselves or their children. The family should be fully informed as best as possible so that there aren't any stalls in the process with them leasing up. The receiving housing authority should also keep the initial housing authority notified of the family's process as they are securing and looking for housing in their jurisdiction. In closing, the number one best practice is to manage portability efficiently and operate timely so that additional burdens are not placed on the family.
All right. Thank you, Tisa. It looks like we have several questions that came through in the chat. And so before we kind of dive into that, just wanting to let everyone know that the presentation, the recorded version of it, as well as the slides and any question and answers that we go through today will be posted on the HUD Exchange here in the next few weeks. And so as it relates to questions in the chat, we will do our best to answer those questions here live. And then if there's anything we aren't able to answer right now, we will post the answers to those questions to the HUD Exchange, as well as our answers on the call right now. So with that, I'm going to go ahead and just start reading through questions that we've received on the chat. If you have any additional questions from the presentation material, please feel free to type those questions into the chat. So the first question is, can the RHA refuse to accept a portability request if the porting family has less than 60 or 30 days remaining on the voucher search time?
The receiving housing authority would have to, or the family would have to contact the initial housing authority to grant them an extension. They can't necessarily refuse it, but I should say the initial housing authority has to grant the extension to the family.
And then I think, and kind of to add on to that, Tisa, I think during your presentation, you talked about the receiving housing authority needs to add an additional 30 days to the expiration of the initial housing authority's voucher once the voucher is issued by the receiving housing authority. Am I saying that correctly?
Yes, you are. And the
Okay.
extension that the receiving housing authority gives can't expire, of course, before the initial housing authority's voucher expiration date.
Let's see. The next question is, what if the 52665 and 50058 are received after the 10-day window?
If the information isn't submitted timely, the initial housing authority can decide if not to accept the billing if the receiving housing authority is going to bill. It is so that the family isn't burdened. It's good practice for the receiving housing authority to contact the initial housing authority, inquiring about the information, but you do not have to accept it if it's received after the deadline. The initial housing authority would be responsible for you not accepting that billing.
All right. The next question is, are there any restrictions or exceptions on extending a voucher for a tenant who needs specific accommodations for a disability they are having difficulty finding a home? Do you want to respond to that one, Tisa?
Yes. So the initial housing authority and/or receiving housing authority should allow as a reasonable accommodation if the family meets the criteria additional time to search for a unit. Remember, we want the family to have as less burden as possible, but still be in line, maintain compliance with the program requirements. But if, again, as a reasonable accommodation, you can extend the search time for the family if they prove that they have been searching and that they do indeed need to be accommodated reasonably.
The next question is, port-in packet 50058 does not have data of the date entered, the waiting list, the zip code at admission, and homeless or not at admission. Can we have, or can we get the agency to have this information when sending the port packet?
Yes, so the initial housing authority should be contacted for them to enter that information on the 50058 so that you have it when the family leases up. It should be there. I'm not certain why or how it wouldn't be, but that information should always be maintained on the 5/8. If you run into a situation where it's not, then absolutely the initial housing authority should be contacted for that information and to update the family report to send.
All right. The next question is, can the IHA issue a future dated voucher? If so, is the RHA required to issue any paperwork or brief the family before that date?
No, so vouchers should never be dated in the future. They should always be dated when you are actually issuing that family's voucher. I guess the second part is answered in the first because the voucher can't be dated in the future. So if the family, you're issuing it today, it has to be dated today.
Okay. Thank you, Tisa. The next question is, if a portability family transfers within the receiving housing authority's jurisdiction, when is the billing deadline for the transfer?
So are you asking about the initial billing?
So I'm thinking if Georgia voucher transfers ports to Tennessee in 2020, and Tennessee is billing the Georgia Housing Authority, and now the family transfers to another unit within that Tennessee jurisdiction, when is the billing deadline for the transfer? Not the initial transfer from Georgia to Tennessee, but from Tennessee to Tennessee. So a type 2 or a type 758.
It sounds like you're saying if there was a change in the circumstances. Is that correct? Am I understanding correctly?
Or a change in
So,
unit.
so that would be 10 business days. Any changes would be 10 business days since it's not the initial billing.
Okay. All right. So the next question is, what happens when a regular billing for an interim is not received during the correct time? Is the RHA forced to absorb, or can the IHA deny the billing charge until the following month?
The billing can be denied. The IHA wouldn't be forced. It could be, I shouldn't say wouldn't, but normally the billing can be denied for that transaction.
So for an example, if you had an interim that was effective July 1st and you didn't process the actual 5058 transaction until August 5th, because it's beyond that 10-day billing period for a change, it could be denied for if you're making a retroactive July 1st change. Am I hearing that correctly, Tisa?
Yes, and the admin fee may be reduced. So because that billing would be late, and HUD may reduce the admin fee.
Okay. So that's an excellent question. And so if you are a PHA who is billing ports, that you make sure you're timely processing any interim recertifications. The next question is, if the IHA honors a late billing at any time, can the IHA refuse to accept a late billing in the future?
That's a great question. They could, so prior to they honored the billing, it was late, they decided that they don't want to continue to do so, they may refuse to accept that late billing.
The next question is the IVT report required with the EIV request?
No, so the income verification tool is not required. It's typically used when interim transactions are processed, but when you're sending the EIV report as a part of the portability packet, you're just sending that report along with the current income verifications.
The next question is, several RHAs do not submit the updated 52665 after the family has been recertified. Should the IHA continue to submit payments to the RHA if the recertification is expired?
They should, if the RHA is going to continue to bill and not force the absorption, so you can continue to update and process the research and sending those reports to the IHA.
So there were a couple other parts to that question. I only read you the first part of it. So the second part of that question is, or should the IHA wait until the RHA has submitted an updated 52665?
So they should wait until the 52665 has been updated.
Okay. The next question is, what are all the required documents that the IHA must provide to the RHA?
So the IHA must provide a copy of the voucher issued to the family, and it has to be signed and current. They also must send a copy of the 52665 form, which is the family report, and part one of that report must be completed by the IHA. The second part of that form will be completed by the RHA once they send it back. The IHA must also send copies of updated income verifications for the family and the EIV report, and then also a current copy of the 50058 form. Those are the required documents, but some PHAs decide to send copies of the photo ID, citizenship status of the family, etc., to help the process move along quickly, but those are not required. But it is best practice to send them so that the family can lease up as quickly as possible and their paperwork can be processed by the RHA as quickly as possible.
Yeah, agreed. Great point. Next question is, will you be speaking on EHV portability for when an RHA does not have an EHV program and the benefits of absorbing or billing? So let's talk about special purpose vouchers. EHV is a special purpose voucher. Tisa, do you know if EHVs are able to be ported?
I don't think so because not all housing authorities have EHV vouchers, but in my experience, none of them have been able to be ported.
Okay. So that's a great question. I think we will follow up, and when we post this to the HUD website, expand on the answer to that question at that point. All right. The next question is, can you report a port in VMS that has a payment on hold? I can't get it to accept a voucher number, but 0 in HAP. So that's a great question that we will also answer in the FAQs, but I would imagine if you're unable to submit your VMS report because you have a voucher in there with a 0 HAP, it's rejecting it. You may just need to wait until you get that voucher off hold and then do a prior month correction for the month in which that voucher leased up. But we will verify that and post the response to the HUD Exchange once I can verify that. That's a great question. Because I understand why it would be denying it, because you can't lease up a 0 HAP voucher. So we will get some clarification for you on that. The next question is, anybody out there have a spreadsheet in which they track port data, or is it all off of your software? So I don't know an answer to that. Tisa, do you have any experience in tracking port data, whether it's in software or on a spreadsheet?
Yes, I have experience in tracking it on a spreadsheet. Software tends to take a little bit more time. You'd have to, of course, get your local IT department involved, but tracking it on a spreadsheet is, to me, much more useful because it can also be shared by sending the link amongst your agency.
All right, the next question is, should the issue date of the voucher be issued immediately or when the lease ends? If the RHA receives a voucher with a future date, upon request, can the IHA update their voucher?
The issue date of the voucher should always be the date that you are actually issuing the voucher. So again, if you're issuing it today, it should be today. It should never have a future date, or it should never be changed unless you accidentally put in the incorrect issue date. But it should always be the day that you're actually giving the voucher to the family to search for a unit. And keep in mind, because there is a certain time frame that the family has to search, so you want to be cautious and compliant when actually issuing the voucher and giving the correct issue date.
The next question is, a PHA will not accept a port in with less than 60 days left. Sometimes the family has no extensions left. We do not have to grant them an extension, do we?
So as the receiving housing authority, you must give them an additional 30 days. So are you saying that they ported into your jurisdiction and you had already given them the 30-day extension? Because if not, as the receiving housing authority, you do have to grant them an additional 30 days.
So what I think, let me rephrase the question. What I think it is this is a question coming from an IHA saying that a different housing authority will not accept a port that has less than 60 days left to expiration.
So some receiving housing authorities, they won't accept the information because they do have not enough time to search. In my experience, the receiving housing authority should contact the initial housing authority asking. You don't have to give them additional time if it's a family that just drug their feet or they really can't prove that they were having extreme difficulty in searching for a unit. The initial housing authorities, they may choose not to. They don't, it's not a requirement that they have to, but I think in the best interest of the family, they should, and the receiving housing authority should communicate and try and get them to extend the time, unless, like I said, it's a family where they haven't been actively searching for a unit.
All right, the next question is, what if an RHA notifies you of fraud that goes way back and pays you back? What is the best way to handle this in VMS, especially if this goes beyond the time frame that VMS will allow you to make the change? So that's a great question. I don't have the answer for you at the moment. Tisa, any thoughts on that question?
I've never seen it because most PHAs are actively looking and monitoring the EIV reports. They have compliance measures set up to avoid issues that way. So I don't have a question. I've never seen it.
Okay. Just for the sake of thinking that through. So the receiving housing authority notifies you of fraud that goes way back, and then the receiving housing authority reimburses the initial housing authority. How do you handle that in VMS? Okay, I'm gonna just take a note here. The next question is, since the initial housing authority does not EOP when the receiving absorbs, does the initial leave it as a 5 until the tenant leaves and the receiving PHA, then both housing authorities do an EOP?
I have seen cases like this before, and it has been constant follow up and contact, and in some cases, assistance from HUD to get the initial housing authority to process the EOP. I don't suggest that it's left as a 5. Just keep following up, contacting, and if necessary, ask for the assistance of your local HUD field officer to get the initial housing authority to process the transaction. The second part of that question was, is it the receiving PHA both doing an EOP?
Yeah.
Is that, yeah, yes, the initial housing authority should process it first. If for some reason you can't get them to process the EOP, then my suggestion is to go ahead and process it. There will be a error, possibly a pick error, but again, communication will be key, and just contacting the initial housing authority or your local HUD field officer for assistance.
The next question is, when issuing a voucher to a tenant porting in, do I use the bedroom size that's on the voucher?
No, so whatever bedroom size the family qualifies for in your jurisdiction will be the voucher size that you're going to issue to them. As mentioned in the training earlier on, families need to know that it's possible that their subsidy size may change. So just because they have a 2-bedroom voucher where they're currently living doesn't mean that they'll still maintain that same voucher size when they lease up in another jurisdiction. You have to follow your subsidy standards.
All right. The next question is, how does the MTW program impact the portability process?
The Moving to Work program is different from regular agencies that don't operate as a moving to work agency. The main difference for moving to work is that they're able to come up with their own set of rules that normal or other rather PHAs must follow. There are some things that allow them to deviate or navigate away from the process, but it can be very convoluted because they do operate totally different than the regular HCV programs. But of course, their policy must dictate how they operate as it relates to portability.
The next question is, can you review the special programs information? Are FUP and non-elderly disabled allowed to port if the receiving housing authority doesn't have that program?
So FUP vouchers, voucher holders, and non-elderly disabled can port, and the portability rules will be the same as it is for regular voucher holders. There are a little bit of nuances that are specific to the program, such as the family following the FUP program guidelines or the non-elderly disabled guidelines, but those voucher holders are absolutely able to port.
The next question is, what if the family changes their mind after getting additional time in the receiving housing authority? Does the initial housing authority have to honor the extension if the voucher originally expired from the IHA?
So the family decides they don't want to port, and the initial housing authority has granted them an extension.
It sounds like to me, Tisa, the question is, the receiving housing authority granted an extension beyond the original amount of time from the initial housing authority. And now the family is no longer going to the receiving, but back to the initial housing authority. Does the initial housing authority have to honor the amount of time on the voucher they received from the receiving housing authority?
Yes, so if as long as the voucher hasn't expired, including the extension, then the request still has to be honored. The family can't be denied if they still have time to search on their voucher.
The next question is, if we receive the HUD 52665 and the voucher has a future issuance date, do we deny it until they correct the form?
Yes. I'm not sure how, in my experience, I don't know why they would put a future voucher issuance date, but I would contact, for compliance purposes, the initial housing authority for them to correct and use the date that the family has actually been issued a voucher.
The next question is, if the initial housing authority accidentally processes an EOP instead of a port out, so they process a 6 instead of a 5, what steps need to be taken to correct this, and who is responsible for making the corrections?
It would be the initial housing authority. They would have to correct it because it would have to go back through HUD's PIC system. So they would have to correct it and then port the family out so that they're correctly showing in PIC and so that the receiving housing authority can do the transaction for.
All right, the next question is, can a receiving housing authority refuse port-ins from an initial housing authority that has issues with very late billings, months or years later? Do we need HUD approval?
The billings can be refused. You don't need HUD approval. It is stated in the regulation that you can force the refuse, I'm sorry, that billing, especially if they're constantly late with sending it, then you can refuse it.
I think to kind of elaborate on that question a little bit more, I think the receiving housing authority is asking if they can refuse to accept a port in from an IHA that they've had issues with over the years. So not necessarily refusing the billing, but refusing to port the voucher into their jurisdiction.
No, port-ins can never be refused. It's not fair to the family if that was allowed, so the port-in can't be refused. It would probably be best practice to absorb the family if you could, but you can't refuse to accept the family.
The next question is, does current information mean current since last annual certification?
Yes.
All right. There's another question. It says, we have received EHV port-ins. Okay, so somebody is responding to the question about EHVs and can they be ported in, referencing two different PIH notices. So PIH notice, if you have a question as it relates to EHVs, you can review PIH notice 2021-15 or 2021-20 as it relates to EHVs and porting. All right, the next question is, in PIC, will the portability family show up in the initial IHA report or the RHA report? So I think the question is, how will the family who's ported show up? Are they going to show up as on the IHA side or the RHA side?
If they're porting in, then they will show up on the RHA side if they're porting into your jurisdiction.
Okay, and now we've got another response saying yes, EHVs follow most of the normal portability rules of the HCV program with a few alternative requirements. So again, referencing PIH notice 2021-15 and 2021-20. Okay, here's another question. I understood you say that an RHA does not send an updated 5058/52665 at recertification, that the IHA should wait to continue paying until they do so.
So they're wanting to know if the receiving housing authority does not send an updated 5.8.
Yeah, yeah.
And what is that in reference to? Was it in reference to
I
the
think,
billing?
let's see. Yeah, it was in reference to the billing. So the receiving housing authority, it sounds like to me, and I'm kind of, it sounds like to me that the receiving housing authority did not send an updated 5058 or 52665 from a recertification that was processed or not processed? And should the initial housing authority wait to continue paying because they didn't receive, sounds to me like they didn't receive a billing with the updated 5058 or 52665 for a recertification that was due? So it sounds like it was a late re-exam or a re-exam where a 50058 and 52665 was not submitted on the billing side.
And so the receiving housing authority wants to wait to continue paying. They should continue paying until the updated information is received. Is that their question?
Yes.
If to wait?
Yeah.
Yeah, so they should continue paying until they have received the updated information.
Okay. And that kind of goes into what was mentioned earlier in your presentation about you need to submit any changes within 10 days of the date that something changed, right? So if a recertification, or if you're paying for the billing and you don't receive updated billing for a change that happened, you're going to continue to pay the billing amount that you were paying until you get an updated 52665 or 5058, correct?
Correct.
Okay. All right. Another question is, can a family keep transferring to different PHAs to get additional time? And is there a time limit on those extensions?
Yes, so voucher extensions do have a time limit, and the initial search time is 60 days. Most housing authorities will only extend it for 30. Some will go ahead and extend it for the full 60 days, but they can't keep transferring after the full voucher limit has expired. So it's initially 60 days and then another 60 days if it is necessary. But after that, they can't be granted any additional extensions.
Okay. The next question is, if you have a tenant coming in with a 2-bedroom port, but then would be considered underhoused, must we issue a voucher that is considered the correct size per regulation and admin plan?
Correct. So the PHA policy on subsidy standards would rule, and of course, you want to make sure it's in line with regulation. So you would right size the family and issue the voucher that they qualify for and wouldn't consider them to be underhoused.
The next question is, if an initial housing authority sends an email stating that they are allowing their voucher holder to have X unit size due to a reasonable accommodation when they are ported in, can this be accepted, or does the receiving housing authority need an official document from the initial housing authority?
You should ask for, and the initial housing authority should send the official document so that you have it for compliance and record keeping purposes. If they state it verbally, you'd always want to get something in writing confirming why they need a bigger bedroom size or whatever the accommodation is for.
The next question is, can the porting individual decide that they no longer want to port after they have started searching? And then the continuation of the question, or second part, is what are the consequences?
Yes, so families can at any time decide they no longer want to port. The only consequence would be that they don't have additional or much time to search for a unit. So, yes, they can decide that they no longer want support.
The next question is, can you review how a PHA should fill out numbers 10 and 11 on a 52665 form?
10 is the initial PHA admin fee. Is that what that's saying? I'm sorry, I'm going
Yeah.
off from memory. Okay, so line 10 will be completed by, or this first part will be completed by the initial housing authority, and the housing agency will put their admin fee. So whatever their ongoing admin fee is. And then line 11 would be 80% of the ongoing admin fee. So you would take line 10, whatever that admin fee is, times 80%, and that's the amount for line 11.
The next question is only a 5 or 6 can be submitted to pick.
If the family is porting out, then the initial housing authority is responsible for submitting a 5. So, and then the 6 would be if they're being terminated. And those aren't the only transactions. I really don't understand the question. Those aren't the only transactions that could be submitted to pick.
The next question is when do we process pick showing that a tenant is ported out? Do we wait until they are housed at the RHA or as soon as they have vacated their housing in the IHA?
That's a good question. Best practice to go ahead and process them as a port out after you have sent all over the paperwork, their voucher was issued. You really don't want to wait until they have leased up, because when the receiving housing authority is ready to lease them up, then the initial housing authority should have had the port out transaction in the system so that you're not delaying the receiving housing authority.
The next question is, if the IHA voucher issued is greater than the RHA, will the RHA use the voucher extension date of the IHA to include the 30-day allowance? Let me reread that to you, Tisa. If the IHA voucher issuance is greater than the RHA, would the RHA use the voucher expiration date of the IHA to include the 30-day allowance? Does that make sense to you, Tisa?
I think I understand. So the RHA can't issue a voucher that expires prior to the IHA's voucher expiring. So if the IHA's voucher expires on October 30th, the RHA's voucher would expire 30 days after, or a day after that. If I'm understanding the question correctly. Did I answer that question, Mike?
I think so. So the RHA voucher expiration cannot be less than the IHA's initial voucher issuance date, right?
Correct. Correct.
Okay. The next question is, when does the initial billing begin for the receiving housing authority?
So the initial billing must be submitted within 30 days.
The next question is, what's the regulation that states 120 days is the maximum amount of time permitted to be issued on a voucher? Please and thank you. So I don't know what that regulation is off the top of my head. The one thing I would say as it relates to voucher, how long you can use your voucher for, right? Different PHAs have different policies. I think there's some discretion to how long the maximum amount of time the PHA can allow a voucher to be extended through, specifically as it relates to the issuance of voucher in relation to the streamlined waivers that are applicable through the end of 2022, in which PHAs can issue a voucher and extend that voucher beyond whatever is listed in their administrative plan. So I say this to say different PHAs have different policies on the maximum amount of time a voucher is allowed to be issued. And right now, it's kind of discretionary for any PHA who has approved streamlined waivers or expedited waivers through HUD, which can extend the amount of time that a voucher can be issued basically through the end of the year. I hope that answers your question. The next question is it a HUD violation if you do not issue a voucher to a port-in?
So the receiving housing authority is not issuing the family a voucher when they port in?
Yeah, I would take it to to mean that, Tisa?
Okay, yes. The voucher, Receiving Housing Authority must issue a voucher to the family once they port in.
The next question is, once the IHA has sent the paperwork to the RHA, if the family has changes in their income or household composition, whose responsibility is it to update those changes?
The initial housing authority should update the changes. The family should be contacting them because remember, the receiving housing authority hasn't started administering that voucher yet or hasn't absorbed it. So those changes should be reported to the initial housing authority for them to update.
Until that family leases up, right?
Correct.
Okay. So if you have a family who's porting from Georgia to Tennessee, family was issued a voucher, and then the family has a change in income and composition, and they're still, that should be completed by the Georgia PHA. Is that what you're saying, Tisa?
Correct.
Okay. So the next question is, if the receiving housing authority is absorbing, should they mark it as a type 5 or keep it, or a type 5 or a type 6? So if the receiving housing authority is absorbing a PHA, should they be doing a type 5 or a type 6?
It should be a 5 for port move out. Type 6 is if the family is being terminated. So if their voucher expired or other reasons for termination, that's when you'd want to use the 6.
The next question is, what is the ruling on admitting an applicant who is over income?
An applicant family must be within the income limits if they're in the initial jurisdiction or the receiving jurisdiction. You can never admit a family who was over income for the program. Keep in mind that rule only applies to applicant families. Participant families, their income is not redetermined.
All right, so we just got another question. Question is, can an IHA deny the change for composition if the family is moving to an RHA with a smaller bedroom size policy? i.e., will they get a bigger bedroom at the RHA if they add more family members?
So, yes, if the family is adding family members and it's in line with the RHA's policy, then the voucher size issued has to be in line to accommodate however many family members will be residing in the unit.
Okay, the next question is it a HUD violation if you do not issue a voucher for a port-in within 2 weeks?
The regulation does state that the voucher has to be issued within 2 weeks. So essentially, you would be in violation of the HUD regulation because remember, HUD wants to ease or lessen the burden on the family as much as possible. So the regulation does state that the voucher has to be issued within 2 weeks.
Okay. We don't have any additional questions in the chat. We'll stick around for a few more minutes and see if any other questions come through. But that pretty much concludes our webinar for today. We want to thank you for taking the time to participate, and thank you for all the questions. It made it a very interactive session. So we appreciate your feedback. And again, look forward to the information presented in the training today to be provided in the next few weeks on HUD Exchange. Thank you all and have a great afternoon.